Okay, so today we'll look at the topic case for the defense. Case for the defense. Now, this topic is also very, very important. It's very important. Now, the essence of this topic is for you to know after the prosecution has finished its case. Like we are in the last class we were talking about Bukola and the examination of witnesses and all that. You understand? So you might want to recollect, about what we said in the last class about Bukola coming to testify for the prosecution and all. You understand? So the essence of this topic is for you to know what the defense can do after the prosecution is done with his case. The prosecution usually starts a criminal trial. You understand? He's usually the one who comes first to give evidence, to call his witnesses. So now, immediately after the prosecution has done, you understand? Immediately after the prosecution has done everything that he needs to do, he has called all his witnesses, he has adduced evidence, he has tendered document through witnesses, he has done everything that he needs to do. You understand? Then what are the options available to the defendant? You understand? Will the defendant just enter and start calling his own witnesses? You understand? Or will the defendant enter a no case submission? Or will the defendant choose to rest his case on that of the prosecution? You understand? That is the essence of this topic. You understand? That is exactly the essence of this topic. So we know that a criminal trial commences. A criminal trial from arraignment. You understand? And then after the arraignment, the court usually adjourn to another day for trial to commence. You understand? To commence properly. That is hearing to commence properly. And then once the hearing commences, the prosecution usually opens the stage. You understand? And he usually does that by a summary of evidence, which we call opening address. So the prosecution will usually come, he wants to open the floor for the case to start. He usually do what they call opening address. That is by stating his case, stating the fact of the case, evidence that is going to be tendered, the amount of time he's going to use, witnesses that are going to be. He will just summarize everything that he wants to do. You understand? He will just summarize everything that he wants to do and then start calling his witnesses. You understand? Then start calling his witnesses. And then it's relevant to note that once the trial has commenced and then witnesses has been called, if prosecution, for instance, called three witnesses, if, for instance, the prosecution called three witnesses, and then one of the witnesses giving evidence in the witness box, the law requires that the two other witnesses should leave the courtroom. You understand? If you do your externship, you will notice that the registrar will usually say other witness in this particular matter who knows that they will give a testimony in this case should please leave the courtroom. That is more like an instruction. It's not an order. It's not mandatory. It's not compulsory. You understand? A witness can decide to stay. It doesn't mean that his evidence will no longer be admissible, but it reduces the weight that the court will place on his evidence. You understand? The essence of that witness leaving when the other witness is testifying, is for him not to know what that one said. You understand? If they are really saying the truth, even if they are giving testimony at different times, when one person is absent, their evidence will definitely rhyme. You understand? It will definitely rhyme because they are saying the truth. You understand? So if a witness refuses to leave, his evidence will still be admissible, but it will carry less weight. You understand? The court will attach less probative value to it. And then it's relevant to note that if, for instance, the legal practitioner, that is the counsel, for instance, the defense counsel will give evidence in that case, or the defendant himself, will testify in that particular matter. You understand? He's not required to leave. So these witnesses should leave does not extend to the defendant or the counsel, where any of them will give evidence. And then evidence that witnesses will give has to be on oath. You understand? So he has to be sworn to. It goes to show the weight of the evidence, and it goes to ensure integrity. The person will usually say the evidence, this testimony you are giving, you know it to be the truth and nothing but the truth. So help me God. You swear by the Bible or you swear by the Quran. You understand? And then if you don't want to swear, you can just affirm. You can make an affirmation. You understand? You can make an affirmation. And then it's relevant to note that the prosecution the prosecution is not bound to call a particular number of witnesses. I think we have said this before. You understand? There is no statutory requirement for the prosecution. The prosecution can decide to call just one witness. Prosecution can decide to call just one witness. It's not about the quantity of witness you called. It's about the quality of the evidence they give. It's about the probative value. It's about the character and the nature of evidence that is adduced by them, not necessarily the number of witnesses you called. But we know that where corroboration is necessary, if the law has stated that the person cannot be convicted unless at least two witnesses are called, we know in that case the prosecution must call at least two witnesses. Miss Ade against the Queen and all. And then the judges, the judge or the presiding officer handling that particular case, may also question witnesses to ensure justice. The judge may question witnesses to ensure justice. But then he must remain impartial. You understand? Yes, the judge has the right to put questions across the witnesses. To ensure fairness of the particular case and ensure that there is no miscarriage of justice. But then he must not be too excessively involved. You understand? He must not be too excessively involved in the case. We practice what we call the acquisitorial system of a criminal trial. You understand? Not just criminal trial, the acquisitorial justice system, where the parties, their counsels, we have to give evidence, and then the role of the judge is just an independent umpire who does not enter the arena of conflict, lest the dust of the conflict be cloud his vision. You understand? So the judge must not be too involved. He can put questions across the witness, yes, but he must not be too involved in order not to breach our acquisitorial system. And then once the prosecution is done with his case, what happens? The prosecution will usually end with a statement such as, "My lord, that will be all for the prosecution," and then he hands up. So now, once the prosecution is done with his case, now, what options are available to the defendant? What options are available to the defendant after the prosecution has finished his case? The defendant has three options. He has the option of either entering a no-case submission, or resting his case on that of the prosecution, or he can decide to enter his defense. So now we'll examine these three options. Understand? So the first one is no-case submission. A no-case submission is a written submission by the defense based on the argument that no prima facie case or no prima facie evidence exists, and he has no case to answer. Understand? So if maybe prosecution, for instance, he calls witnesses. When the prosecution started, he called witnesses. The witnesses came, and the evidence they were giving was very, very incoherent. They gave nonsensical evidence. Everything they were saying was just incoherent. Someone is charged for the offense of murder, and then it cannot even be established that he killed the person at the crime scene. There was no way they could not link the defendant to the murder of the victim. In that case, they have failed to prove the necessary ingredients of that particular offense. If you are the defense counsel, there's no need to waste time. There's no need for you to start calling witnesses. There's no need to do all that. You can just enter a no-case submission. Now, the implication of a no-case submission is that evidence adduced by the defendant is incoherent. You understand? The evidence is not such that the defendant was linked to the commission of the offense. You understand? The evidence is not in any way valid. So there's no case for you to answer. The prosecution and his witnesses were just blabbing. You understand? There's no case for you to answer. And you know that this no-case submission, the court can also raise it on their own. The court can, on their own, in the interest of justice, raise it. This prosecution has not done anything. He's just wasting our time. It's a no-case submission. There's no contest here. There's no case. There's no valid case here. You understand? And then a no-case submission, has to be raised by the defendant. Immediately the prosecution has ended this case. You understand? So immediately the prosecution has ended this case, and then the defense counsel has three options. Either to enter a no-case submission, or to rest his case, or to enter his defense and start calling his witnesses and all that. You understand? So it is at that point, immediately the prosecution is done, he has to enter the no-case submission. You understand? Immediately the prosecution is done, he has to enter he has to enter his no case submission. He cannot enter no case submission on appeal. You understand? He cannot enter no case submission on appeal. He cannot open his defense and call witnesses and then later say he wants to enter no case submission. No. Immediately the prosecution is done with his case. The prosecution has said that is all for the prosecution. At that point, the defense counsel should enter his no case submission. So what are the grounds? What are the grounds and the circumstances in which a no case submission might be entered? So one of them is where the prosecution has failed to prove the essential ingredients of the alleged offense, where the prosecution's evidence has been discredited by cross-examination, where the prosecution's evidence is manifestly unreliable, that no reasonable court or tribunal will safely convict on it, where there is no evidence linking the defendant to the commission of the offense. Understand? So in any of these instances, whenever there is no, whenever the prosecution has failed, you understand, his evidence is not in any way valid. He has not proven any of the essential ingredients. You understand? He has not proven any of the essential ingredients. Or maybe after the prosecution called a particular witness and then you as a defense counsel, you examined that witness and then you battered everything the witness said. And then it appears to the court that yes, this evidence has been battered, you know. And then where the prosecution's evidence is manifestly unreliable, that no reasonable court will convict on it. Maybe witnesses called are just giving incoherent evidence. What they are saying does not make, they're just blabbing, you know. In that case, you should enter a no case submission. And then what does the court do? Like, what does the court do when a no case submission is made? Immediately the defense counsel enters a no case submission, the court has one duty, and that duty is for the court to establish whether or not a prima facie evidence was made out against the defendant. You understand? You know, ordinarily you cannot be entering a no case submission when the prosecution has made out a prima facie case against you, where you have a case to answer. You know, the prosecution has tried to prove his case beyond reasonable doubt, and you are entering a no case submission. That's not, it doesn't make sense. You understand? It does not make sense. So what the court does, immediately a person enters a no case submission, the court will have to look at the evidence of the prosecution. The court will have to examine the evidence of the prosecution, whether or not there is really a prima facie case. You know, if there's when we say prima facie case, we mean, is there any ground for further trial? Is there any reason why we should proceed with the trial? You understand? So if there's a prima facie case, no matter how slight, no matter how insignificant the prima facie case is, that no case submission is going to be overruled, and then trial is going to commence. But if no prima facie case exists, you know, that no case submission is going to be upheld, and the defendant is going to be discharged. You understand? The defendant is going to be discharged. And then can the court compel the defense to open his defense after a no case submission is overruled? So where, for instance, the court overrules a no case submission. Where, for instance, now the court overrules a no case submission. Can the court compel the defendant? Maybe the defense counsel entered a no case submission and the court overruled it. Say, how can you be entering a no case submission in this matter when they have made out a prima facie case against you? My friend, open your defense, call your witnesses. Can the court compel the defense to open his defense? You understand? Can the court compel the defendant counsel to open his defense, you know, to call his witnesses? You know, the court cannot do that. You understand? If the court overrules a no case submission, the defense has two options. You understand? He can decide to rest his case on that of the prosecution, you know, or he can decide to open his defense. You understand? So the court cannot force him to open his defense by force. You understand? It's not possible. And then what is the effect of a discharge on a no case submission? You know, we talked about the fact that once the court finds that there are indeed no prima facie case against the defendant, the court will have to discharge the defendant. You understand? So what is the nature of that discharge? What is the effect? What is the effect of that discharge on a no case submission? Now, such a discharge is a discharge on the merits. You know, the implication is that it terminates the proceeding. The defendant cannot, you know, he cannot be arraigned again on the same charge. You understand? And the defendant cannot be convicted for another offense based on the same fact. You understand? Based on the same fact. It's not possible. is not possible. So in other words, you can say a discharge on a no case submission is more like an acquittal. You understand? It's an acquittal because you cannot rearrange the defendant again on the same charge and the same fact. It's an acquittal. That discharge operates as an acquittal. So now we look at the rulings upholding or refusing a no case submission. So now, what is the nature? The nature of the ruling upholding or refusing a no case submission. So there is this principle. Generally, a ruling of the court on a no case submission is required to be tied to the submission. If the court is making a ruling, maybe the defendant counsel entered a no case submission, and then the court has considered it and wants to make a ruling on it. The law requires that such ruling must be tied to the no case submission, and then such ruling must not be too lengthy. It must not be too long. Neither should it be such as to fetter the discretion of the court. We'll explain this very well. But if you look at the second paragraph, you'll understand the first paragraph. Now, where the court upholds a no case submission, the law is that the ruling should be detailed like a formal judgment, because such a ruling is a final decision within the meaning of Section 318 of the Constitution. So if the court upholds a no case submission, the effect of upholding a no case submission is that you discharge the defendant. Trial has ended automatically. That matter cannot be brought to court again on the same offense. It's not possible. The person has been discharged, and it operates on the merit. The person has been acquitted. You understand? So such a ruling upholding the no case submission must be detailed. You understand? It must be like a formal judgment. You will have to give your reasons, state the grounds, consider the facts. So it has to be detailed like a formal judgment. But when we get to the topic judgment, you will notice that every judgment must have certain contents, certain characteristics for it to be valid. You get. So and then they say, but where it is refused, but where a no case submission is refused, that is, the court overrules it. Now the law is that such ruling should be brief and tied to the submission alone. You understand? So where the court refuses a no case submission and allows trial to continue, such ruling overruling that no case submission has to be brief. It doesn't have to be detailed. It has to be brief. It has to be short. And then such ruling should be tied to that submission alone. You understand? The judge should not go into substantive issues so as not to fetter his discretion during the formal judgment. So imagine if, for instance, the defendant counsel entered a no case submission after the prosecution tendered evidence and all, and then the court refused the no case submission. The court should just state briefly that it refuses the no case submission. The court should not go into how the prosecution has proved this case beyond reasonable doubt, how he called this particular evidence, how this evidence complied with this. If the court does that during the time he is in his ruling overruling the no case submission, then what is he now going to hold in his formal judgment at the end of the trial? You understand? So that's the essence of the statement. It should not be such as to fetter the discretion of the court. You understand? So if the court is upholding a no case submission, when you uphold a no case submission, it ends the trial. So that ruling upholding the no case submission should be detailed. It should be like a formal judgment. You understand? But if the court is overruling the no case submission, in that case, trial commences. So that his ruling overruling the no case submission is more like an interlocutory decision. It should not be detailed. It should not be long. It should be brief, but then it should relate to the submission made alone. You understand? So the court cannot come in that ruling overruling the no case submission and be talking about how the prosecution proved his case beyond reasonable doubt, how this evidence was called. If he says all those things in a ruling overruling, when trial still commences, then what is he now going to say in the formal judgment? So if he does that, he will fetter his discretion. It's not proper for him to do so. But it's relevant to know that if the judge does so, if in the ruling overruling if in the interlocutory decision which overrules the no case submission, that is in his ruling refusing the no case submission, if it was too lengthy, if it was too lengthy, it does not vitiate the trial. You understand? It does not mean that the trial is a nullity. You understand? It does not mean that the trial is a nullity. The question is whether or not such a lengthy ruling fettered his discretion. It could be possible that he made a lengthy ruling. He went into some substantive issues, but at the end of the day, it could be that his discretion was not fettered. And then during his formal judgment, he also came up with, a lot of principles that he did not touch upon in the ruling refusing the no case submission. And it's relevant to know that the ruling on a no case submission is appealable. You can appeal it. It's an interlocutory decision of the court. If the court refuses a no case submission, it's appealable. You understand? It's appealable. You can appeal it. As a defense counsel, if the court refuses a no case submission, you can appeal against such a decision. You understand? You can appeal against such a decision, but proceedings cannot be stayed. You understand? Proceedings cannot be stayed. Proceedings cannot be stayed. Remember, in criminal trial, we don't, there's nothing like stay or proceeding. And then, ruling of the court wrongly overruling a no case submission. Now, what if someone enters a no case submission? The defense counsel for the defendant entered a no case submission, and clearly there was no prima facie case against the defendant. The prosecution started his case, called witnesses, they blabbed and blabbed, they gave incoherent evidence. Nothing they gave was valid. They could not prove any of the essential ingredients of the crime. And then the defense counsel entered a no case submission, and the court wrongly overruled it. The court refused it. So what if in the course of the trial, the defendant, by mistake, gave an implicating evidence? He gave an evidence against himself that implicated him. Maybe during, maybe for instance, he decided to give evidence in his matter, and then he was now being cross-examined. He was now being cross-examined by the prosecution, and then during his cross-examination, it was extracted. Cross-examination can be very tricky. Understand? So maybe during his cross-examination, he mistakenly admitted to committing the crime. You understand? So in that case now, what is now going to be the position of the law? Now, the law is that such conviction, the court cannot convict him on such an evidence. You understand? The court cannot convict him on such an evidence. The court will not convict him on such an evidence. Such conviction will not stand. You understand? Because the court ought to have, discharged him under his no case submission, which was properly raised but wrongly overruled. But now he ended up giving an evidence implicating himself. You understand? So the court is saying that such conviction cannot stand. If the conviction should stand, it is just as if you are asking the defendant to prove his innocence. You understand? Contrary to section 3605 of the Constitution. And then options open to the defendant upon overruling of no case submission. You understand? So if the no case submission of a defendant is overruled, the defendant can decide to appeal the ruling. You understand? He can decide to appeal such a ruling. He can decide to appeal the ruling while trial commences. Remember, we can't stay criminal proceedings. And then he can decide to rest his case on the prosecution's case. And then he can decide to enter his defense, that is to start calling his witnesses and adducing his own evidence. So what does it mean to rest his case on the prosecution's case? It is also possible to rest your case on the prosecution's case. For me, I feel like it's very similar to no case submission, because at the end of the whole day, you are still telling the court that, although in the case of no case submission, you are telling the court expressly that there is no prima facie case against you. But in the case of resting your case on that of the prosecution, you are by implication also telling the court there is no case against you. So they're a little bit similar. But the essence of resting your case on that of the prosecution is that you don't call any evidence. You are telling the court, just decide this matter on the evidence that the prosecution gave. You understand? You don't want to waste it. In the case of resting your case on the prosecution, on that of the prosecution, you don't want to waste the time of the court. You are telling the court, I rest my case on that of the prosecution. So decide this case based on the evidence that the prosecution gave against my client. You are trying to tell the court, decide for yourself if the prosecution has proved this case beyond reasonable doubt. I don't need to call any witness. You understand? My client does not need to call his own witness. That will prolong this trial. You understand? Just use this evidence that the prosecution gave and decide whether he has proven the case beyond reasonable doubt. That is what resting his case on that of the prosecution looks like. You understand? So where, for instance, maybe evidence adduced by the prosecution is just nonsense. His witnesses were just blabbing. The evidence is weak. The evidence is very weak. The evidence is such that cannot sustain conviction. In such an instance, you can just decide to rest your case on that of the prosecution. But then it's relevant to know that, the court has warned against this practice. The court has warned that resting your case on that of prosecution is very risky. You understand? Before you rest your case, you must make sure that the prosecution's case is not. He must make sure that his case is not strong. You understand? Because when you rest your case on that of the prosecution, it has consequences. It has certain effects. For instance, you cannot call and examine witnesses again. You can't call witnesses and examine witnesses again. You cannot testify, as a defendant, you cannot testify in your own case. If you have something to say, you won't say it again. And then you cannot present your own version of the case. You are telling the court to decide the case based on the version of the case presented by the prosecution. And then you cannot also open your defense again. That is the same thing. You can't give evidence, call your witnesses, and all that. And that was why the court has warned that it is only appropriate for you to rest your case on that of the prosecution only when the prosecution's case is weak, both in law and in fact. You understand? So when the facts given by the witnesses are incoherent and inconsistent, and when the evidence adduced by the prosecution is weak, you understand? That is when it's appropriate for you to rest your case on that of the prosecution. And then what counsel is to do after resting his case on the prosecution is simply by filing his final address and waiting for the judgment of the court. You understand? He doesn't need to do any other thing again. If you rest your case on that of the prosecution, just file your final address and wait for judgment. And then if the judgment is unfavorable, you then the only option left for you is to appeal. You understand? The only option left for you is to appeal against the decision of the court. And then if a defendant does not take any of these two options, he can decide to open his defense. You understand? He can decide to open his defense. So where the court believes that the prima facie case has been made against a defendant, which warrants a defense from him, the court will usually call upon him to make his defense. The court will usually call upon him to make his defense. But now, what if, for instance, the defendant is unrepresented by a counsel? What will happen? Maybe such defendant is unrepresented by a counsel. What would then happen? You understand? How is he going to open his defense? What is going to happen if he's unrepresented by a counsel? Maybe he decided to defend himself. How is he going to open? How is he going to open his defense? So the court will usually inform him. The court will inform him of three options. If the defendant does not have a counsel, the court will inform him of three options. That he has three options. He can either remain in the dock. A person tried for an offense is usually in the dock. The court can tell him, okay, you can either remain in the dock and defend yourself, and in that case, you will not be sworn. That is, there will be no oath taking, and then he will not be cross-examined. But then the consequence is that little or no weight will be attached to his statement. So in that case, where he stays in the dock and defend himself, the court will not attach much weight to what he's saying. You understand? Or he can decide to come into the witness box. He can decide to leave the dock and enter the witness box. And then be sworn. And then in that case, he will have to take oath. And then he will be cross-examined, and then weight or probative value will be attached to his testimony. And then maybe, for instance, he can decide to remain silent if he wants. After a defendant cannot be compelled to give evidence. Or then, if he has any witnesses, the court can say, oh, okay, if you have any witnesses, call them. You understand? Call them to testify on your behalf. You understand? Call your witnesses to testify on your behalf. And then those witnesses, yes, definitely they will be sworn. They will be cross-examined, and then the court will attach weight, to their testimony. You understand? But then, what if the defendant is represented by a counsel? In that case, the court shall call upon the counsel to make a defense for the defendant. You understand? So if the defendant already has counsel, in fact, ordinarily, if the defendant, his counsel is supposed to know what to do. That immediately the prosecution has finished with his case, he should just come and do exercise, either enter a no case submission, rest his case on that of the prosecution, or open his defense. His counsel is supposed to know. So in that case, there's no need to inform him of all these three options because he has a counsel. So where, for instance, Where, for instance, a person does not have a counsel, a defendant is defending himself, and then the court failed to inform him of those three options. The three options I mean now is that he should stay in the dock and testify the consequences, or he should come to the witness box and testify the consequences, or maybe he should call his witnesses or remain silent or whatever. What if the court fails to inform him of these three options? What if the court fails to inform him of these three options? What is the effect of such failure of the court to inform him of these three options? Now, it will depend on the jurisdiction. In Lagos, for instance, they say provided the defendant is represented by counsel, the court cannot be said to be in breach of any duty. So Lagos is saying that if the defendant had a counsel and then the court did not inform him of those three options, there's no point. Understand? There's no point because his counsel ought to know that his counsel ought to know. Understand? His counsel ought to know what next to do. And then they say under the AGJA and ACJ Kano. Now, if a defendant is unrepresented by a counsel, if a defendant is unrepresented by a counsel, and then those three options was not told the defendant by the court. That is, the court did not tell him you can either stay in the dock or in the witness box or call your witness. You understand? If those three options was not told the defendant by the court, they say such failure to inform the defendant does not vitiate trial. It's like it does not vitiate the trial as long as the court called on the defendant himself to give evidence. The court asked him if he had any witnesses to testify on his behalf, and the court maybe heard the defendant and his witnesses. You understand? So failure to do that will no longer be of any effect. You understand? But if the defendant had a counsel, then the court cannot be said to be in breach of the duty, whether or not it informed the defendant. And then we talk about the opening address. Opening address for the defense. We talk about the opening address for the defense. And then we talk about the opening address for the defense. We started this class with the fact that the prosecution usually starts its case, and one way the prosecution starts its case is by conducting what we call the opening address. Where he will have to call the evidence. Where you have to call the evidence, where you have to state, in summary form, the evidence is going to give, witnesses is going to call, and how he's going to conduct his case. Understand? So the defendant too, after the prosecution has finished his case, understand, the defendant will usually do what he calls, like his own is the defense opening address. Yeah, the defendant also conducts. He also does such a thing. You understand? He also gives the court a rundown of what he intends to do. You understand? Especially where he wants to open his defense, he will usually give a rundown of how he wants to carry out his case. The nature of his defense, whether the defendant that is his client to testify, the witnesses he intends to call, and the duration as well. You understand? And the duration as well. And then when the defendant also finishes his own case, he will have to say, "My lord, that is the case for the defense." Understand? So the defense counsel will usually state that, just like prosecution stated its own. Defense counsel will usually state that. And we look at the issue of visit to the locus inquo. Visit to the locus inquo. In class, they distinguish locus inquo and locus criminis, although I don't really see any difference between the both of them. They say one is the exact crime scene, one is the place where the offense was committed. I don't know what's the difference. At the end of the whole day, it's still the same location. You understand? So, but locus inquo, when we talk about locus inquo, we are talking about, for instance, where the offense committed. You understand? Where the offense committed. So it is possible, for instance, that there's a dispute. It is possible, for instance, that there's a dispute. There's a dispute in court, maybe a criminal matter, and then it is disputed from what angle the defendant shot the victim. From what angle the defendant shot the victim or whatever. This visitation to the locus inquo is one of the type of re-evidence. I gave you an example before that re-evidence will have movable and immovable re-evidence. You understand? So when you visit the locus inquo, it's more like immovable re-evidence. You want to see the crime scene. You want to see that particular place where the crime occurred. You want to visualize it for yourself. Okay, this was where he shot the gun from this distance to this distance. He could not have given such a big bullet wound, or he could have given such a big bullet wound because it was shot from this distance. So, so the court will go there themselves to examine and see for themselves the distance from which the said gun was shot. The court can just go there to look at to look at things for themselves. That is what we call loco cinco, visit to loco cinco. And then the law is that the trial judge has to record everything that occurs in that loco cinco. Although failure to do so will not vitiate the proceedings. And then this loco cinco can take two forms. Visits to loco cinco can take two forms. Understand? And the two forms are adjournment to the loco cinco and visitation to the loco cinco. So the court can decide to adjourn to the loco cinco. Understand? The court can go to this is more applicable in civil cases. Understand? All these land disputes where two people are dragging boundary. Who has this boundary? Who has this land? Where did your land stop? We own the land, we don't own the land. All these things. This adjournment to loco cinco and is usually found. In fact, loco cinco is more seen in civil matters. The court will now go to that place and see for themselves the boundary. You understand? So visit to loco cinco may take two forms. It may be adjournment to the loco cinco. That is, the court can adjourn to the loco cinco and then, carry out the proceedings there as if that particular place was a courtroom. You understand? So imagine when the court go to a particular place, like 2 plots of land, goes to that land. They put table, put chair, and then the judge begins to receive evidence. The witness will come before him in that particular land to testify. You understand? So as if that is like a courtroom, the court can adjourn there, and then after that they will then come back to court. You understand? And then they can just simply visit. They can just do what they call visitation to the loco cinco. You understand? They can just simply visit. They can just simply visit the loco cinco. That is where, for instance, let me just say, for instance, two people are dragging land. Two people are dragging land. Who owns this land? Who does not own this land? And then where is the boundary? Where is the boundary? Which side is not the boundary? The court can just go there and just examine. Okay, this is a boundary. This is not the boundary, and come back to court. That is what we call visit to the loco cinco, a visitation to the loco cinco. So in this case, there is no adjournment. You understand? The court is not adjourning there as if it's a court proceeding. They will just go there, take note of disputed issues. You understand? They will just go there, take note of disputed issues, and come back. And then there's something called the ex improviso rule. The ex improviso rule. Now, this rule is available only to the prosecution. You understand? The ex improviso rule is available only to the prosecution. And the essence of the ex improviso rule is that if the prosecution has finished his case, if the prosecution has completed his case, he has called all his witnesses, he has done everything he has to do, and he has closed. Just as, for instance, he has said that is all for the prosecution. So even when he has done this, the court can still allow him to reopen his case. You understand? The court can still allow him to reopen his case. And the purpose of reopening his case is to counter any evidence, that was given by the defense, which the prosecution did not foresee. You understand? Maybe the evidence is such that no person would have reasonably foreseen that the defendant will come up with such evidence. And then in the interest of justice, it is very important that the prosecution replies to such an evidence. In the interest of justice, it is very important that the prosecution replies to such an evidence. The court can allow the prosecution to reopen his case. Ordinarily, if you open your case and you close it, that's it. Ordinarily that should be the end for you. And then the defense will then open his own and then close it, and then they will talk about final address and then judgment. But then the prosecution can be allowed to reopen. It's available only to the prosecution. He can be allowed to reopen his case where the defense has adduced an evidence that he did not foresee. In the interest of justice, the court will allow him to reopen his case to counter that evidence adduced by the defense. And then, like I said, after they are done, we now have what we call final address. You understand? So after the prosecution has opened his case, closed his case, defense has also come. Maybe the defense did not enter no case submission. He also opened his own defense and gave evidence, and then told the court that is all for the defense. Then the next thing now is final address. You understand? The next thing now is final address. Now the final address will allow the parties. The final address is more like a submission. It's also in writing. It's in writing. They will write it and forward it to the court, and they will also exchange it. You understand? They will also exchange it between themselves. And then on that day, which is fixed for final address, they will appear before the court and then exercise or show their advocacy skills. You understand? They will exercise or show their advocacy skills. They will have to persuade the courts, based on the arguments in their final address, based on the arguments inside of that document that they filed before the court. They will just expatiate a little bit on it. They will just expatiate a little bit on it, and then persuade the court to see reasons why the court should give judgment in their favor. You understand? The prosecution will be, stating cases. In the case of this, in the case of that, the court held. The defense will also do the same thing. That is what we call. That's what we call the final address. That's what we call the final address. So in superior courts, it is usually done in writing, but in inferior courts like magistrate courts, it is done orally. You understand? It is done orally. And the final address is a constitutional right. Like, it's very, very important. It's a very fundamental right. You understand? So final address is very, very an important right in criminal proceedings. In fact, failure to grant a counsel his right to final address may vitiate the trial. Understand? Failure to allow a counsel to give his final address can vitiate the trial. And where, for instance, the court hears only the prosecution. Like the prosecution alone makes his final address, and the court denies the defendant his right to make the final address. No matter how cogent the evidence of the prosecution is, such trial, you understand, such trial shall be a nullity. Shall be a nullity. You might see the case of Obodo against Olomo, and you can also look at this final address in criminal litigation by Agaba. I think he actually expatiated on it a lot. But then it's relevant to know that the right to final address may be waived. You understand? The right to final address may be waived. The right to final address may be waived. The right to final address may be waived. And then one thing with final address is that you might ask yourself, who first files the final address, and then who files second. And another thing to know is that that's usually what they call right of reply of the prosecution as well. Right of reply of the prosecution. So now they say the right of the prosecution to reply to the address of the defendant will depend on how the defendant conducted his case. You understand? It will depend on how the defendant conducted his case. So the right of the prosecution to reply to the defense address will depend on how the defense conducted his case. So if the defendant himself only testifies or did not call any witness except the witness as to character, and no documents were tendered, the prosecution does not have a right to reply to his address. You understand? The prosecution does not have a right to reply to his address made to the court. The prosecution does not have a right to reply. So if the defendant did not call, like, it may be the defendant in actually in conducting his case, he didn't call any witness. The only witness he called is just a witness that showed that he's a person of good character, and he did not tender any documents. In such an instance, the prosecution will not have a right to reply to his address at the end of the trial. The prosecution will not have a right to reply on the address. But if the defendant or a witness testified on matters beyond character, or maybe he tendered documents, in that case, the prosecution will have a right to reply. You understand? The prosecution will have a right to reply. The prosecution shall have a right to reply. And then if the defendant introduces new matters in their address without backing them up with evidence, the court may also permit the prosecution to reply. You understand? So where, for instance, in the address of the defendant, he introduced some new issues. Persuading the court on those new issues to give judgments in his favor. In that case, the prosecution can reply to those new issues. The court may allow the prosecution to reply to those new issues raised. But then it's relevant to note that a prosecutor law officer, that is an officer in the Ministry of Justice, always retains the right to reply, regardless of how the defendant conducted their defense. You understand? When we are talking about people who can prosecute a crime, we say private legal practitioners, special prosecutors, private individuals, the Attorney General are usually represented by state councils, understand? So if in the matter, the prosecutor of the case is an officer in the Ministry of Justice, that is a state councils or the AG, those kind of things. So they usually have the right to, they have the right to reply to your address. You understand? They can reply to your address, whether you called a witness or not, as to character, beyond that. Anyhow you conducted your case, it's none of their business. They have the right to reply to your address. You understand? They have the right to reply to your address. I will put you against it, but the right is left for them. You understand? They can decide to reply or not. They can decide to reply or not. So the next topic we are going to look at is judgment and sentencing. Judgment and sentencing.